All right, today we're going to talk about some discovery basics in a divorce. So let's take a step back, high-level overview. What is discovery? Well, the best way I can explain it is during a divorce, you have the right to find out as much information as you need so that you can either enter into a fair agreement or ultimately convince the judge of why you should get the things that you want to get. Once you understand that basic concept, there's a lot of different tools and things that can go into that so that we can get you that information. Now, if you already have that information, you don't need to do discovery and it's not required in every single case. It's something that you should discuss with your attorney at length to make sure, do you have all the information you need? And once you have all that information, then you can move forward. Now, here's the biggest kicker that I like to tell people is, they tell me, I already have all the information, I'm ready to move forward. Well, your spouse also has the same rights. So if they don't have enough information and they want to gather that information, it's their right to do so. Now, some people will wait to issue discovery until their spouse does it. In my office, I believe that we should be doing discovery based upon what is needed. If we're trying to reach an agreement and the other side wants discovery, it's not appropriate just to knee-jerk and do the same back to them simply because they asked for some information. Now, if we eventually have to prepare for trial, of course we're going to need discovery to make sure we line things up. But that's at a later date and time. It's important that you understand you have the right to get information and your spouse has the right to get information. Let's go through the most common types of discovery that you're going to see in a divorce case. Now, the very first thing that you're going to see is what you call a financial affidavit. This is done in almost every single case. It's a financial snapshot of where your money's going, your bank balances, your assets, your liabilities. Everything kind of gets put onto this sheet. Now, some people do them very well, others not so much. But the point is, everybody exchanges these to basically give the other side a fair balance sheet of what's out there. If this is enough, great, we can move on. But if you're considering discovery, a financial affidavit is rarely enough. And let's talk about some of those tools that are available to you so we can figure out what do you need. So before you issue discovery, it's really important first to figure out, what are we doing? Why are we issuing discovery? If we have a better understanding of why we're doing it, then we can guide you into the right tools to get you that information that you need. So when we're dividing property in Illinois, we have 4 components. The first thing is we got to identify. Do we have everything identified? Now, discovery is a great way of identifying property. How? Why? Well, you can get information in a variety of different ways. One of the most common tools is what you call interrogatories. Those are written questions where the adverse party has to give responses back to us in writing. In Illinois, there are some standard questions that you can issue and the other side has to provide them, such as bank account information, do they have a safe deposit box, and many other questions that are going to give you some helpful pieces of information. Now, once you get those answers, you can then decide to do some other things based upon them. You may want to go look at things. You may want to inspect things, which then brings us to another common discovery tool. This is what we call a notice to produce or request for documents. And in this situation, what you're doing is you're sending something to the other side saying, let me see what you have. Now, believe it or not, you can actually do this for other items. Say you wanted to get a vintage car appraised or anything like that. You can say, I need you to produce these things so that I may inspect them and make sure that they're up to standards. But this is commonly used for like bank statements, credit card statements, retirement accounts. Basically, if you're looking for financials, you can use this tool to gather all of this information from the other side. Now, both interrogatories and notice to produce require the other side to do things honestly and truthfully. Sometimes people are not trustworthy. So maybe you want to go directly to the source. If you know where the institutions are that your spouse has money, you can send out a subpoena. So your attorney can send out a subpoena to this institution saying, give me these documents for inspection. You can then go through all of these items and, put your case together based upon what you receive. Now, let's talk about another tool. Another tool used is what you call a request to admit. It's very rarely done in family law, but it can be a very powerful tool. A request to admit, basically, you can create some set of facts and you send it to them where they can either admit it or deny it. And they have to tell the truth. You can also use it to prove that a document is genuine or authentic. So if there's some sort of dispute and you want to narrow that issue down, you can say, hey, admit or deny that this is an authentic copy of the document that we're talking about. And this would be really helpful in moving things forward because it can eliminate the need for bringing in experts or sending out unnecessary subpoenas if both sides can just simply agree on something being authentic. Now, the next tool that we're going to talk about are depositions. Depositions are a great way of gathering information. They're, in my opinion, necessary before litigation when possible. The reason people don't do it is it can also be time consuming and therefore costly in terms of your fees. But a deposition is where you can get the other side or any other witness, quite frankly, and sit them down and ask them questions under oath for up to 3 hours. In my office, I like to do depositions for 3 reasons. And in no particular order, they are to assess the credibility. Does this person come across as believable or not? Because we as attorneys have to give you what we see. And if your spouse comes across very believable or very credible, that's going to be a problem for us. If they come across as very combative and not honest, that can be a good thing for us. So credibility is one thing. The second thing would be to find other discovery based upon those answers. So sometimes their answers may lead us to something else that we then want to go check upon. And finally, the last reason we want to do depositions is I want to lock them in on their testimony. In other words, I don't care what they say. I don't care what their answers are. But when I ask them the question in a deposition, and then I ask them again in front of a judge, I want the answers to be the same. This way, it can eliminate surprises when we're in front of the judge, because ultimately, the judge is going to hear only the testimony in court. They're not necessarily going to hear the testimony that took place during a deposition. So I want it to be authentic, and I don't want any surprises to come out during the trial. All right, let's talk about responding to discovery. If you've received a discovery request, it is overwhelming. Trust me, I get it. I do this stuff every day, and I still look at these things and I say, oh man, this is a lot of information they're asking for. If you've never done it and you start getting these interrogatories sent to you or this request for documents and it's multiple pages of legalese, it can be overwhelming. Don't worry. The very first thing that we're going to do in our office is we're going to get you in and we're going to set up what we call a game planning meeting. We're going to sit down with one of our paralegals or one of our attorneys, and we're going to go through each question that they're asking. Many of the times we already have the information and we just need to reformat it and get it in the right spot. If we don't have it, what we're going to do is we're going to create a plan of action for you. We're going to go through and say, okay, here they're asking for bank statements. We're going to create a plan of action for how are you going to get these bank statements to us. And in fact, we actually have some naming cheat sheets and things like that. So if you really want to save money, we can teach you how to format it and how to do it. So that way my team doesn't have to do it, which is going to save you money in the future. But the point is, we got to gather this stuff. We have to have it organized. So that way, when we send it to the other side, we have all of our ducks in a row and we can say we did everything the right way and that we have it and we have all the proof needed for the court if later issues come about. Now, the other thing with discovery is it's an ongoing thing. The law says that you have to seasonably supplement your discovery. Now, that doesn't say that it has to be every month, every 2 months, 3 months, 5 months, etc. In my office, it's my practice that we like to do it every 90 days, if not sooner. And that might be fact dependent based upon things. In other words, there's supposed to be 4 seasons in Chicago, even though it seems winter's the longest. But the reality is, let's get it done every 90 days. Let's put this stuff together so you don't have to keep sending them into your attorney, but what you want to do is you want to gather everything. So as you get new bank statements together, you put them aside. You get the next one, you put it aside. You get the next one, you put it aside. So that way when you get a request to supplement your discovery, which happens from time to time, you're ready to go and you're not surprised and feeling that overwhelm of, I got to do it all over again. So until your case is done, you need to keep organizing your documents so that way when they're requested again, you have them ready to go. Before you issue discovery, it's important to see how does it fit into your case? Why are you doing this? Well, let's take a step back and first identify what's going on in property and property distribution in Illinois. First, we're going to identify property. We're going to classify property as either marital or non-marital. We're going to value it. Then we're going to divide equitably. So depending upon the issues of your case, it's going to fall into one of those categories. So for example, let's say that you know that your spouse has a bank account, but you're not sure where. Well, that would kind of fall into an identification issue. So where are these bank accounts? Well, we can use discovery as a way of trying to identify that. For example, in the financial affidavit, it should list the bank accounts. In the interrogatories, it asks them, where have you had bank accounts within the last 3 years? They should be able to list them all. One of the other things you can do, so if you do a notice to produce, if you want to send a subpoena so you can see those bank statements, you can look at the bank statements and see if there's transactions in and out to other bank accounts that you weren't familiar with. So unless your spouse has been meticulously hiding these things for several years, you can send a subpoena to any known bank and see if there's other transactions that are going on. The other thing you can do is you can send subpoenas to other places of worth. For example, let's say that your spouse is hiding their paycheck from you. Well, if they work for a W-2 employer, you can send a subpoena to their employer asking for their pay stubs for a period of time. Several times you can also ask for their employee file where they might show their direct deposit records. If you notice that they have a second account, now you've got the information. So now you can send a subpoena off to that account. So that all goes to identification. The next reason you may want to do discovery might be a classification issue. For example, let's say you've been working at a job for 20 years and you've been contributing to your retirement for 20 years, but you've only been married for 10 years. Well, the way the law works in Illinois is the contributions to your retirement account before you were married are considered non-marital. Everything after you were married is considered marital. But here's the tricky part. You have the burden of proving it. So you have to show what was in the account when you got married. You could send a subpoena to your own employer. You could ask to get those records and show what was in the account before you got married. Or for example, let's say that you were trying to make an argument that the savings account you have came from an inheritance or a gift from somebody else. Well, you need to get the records to show how the money came about and was put into that account. And by having this discovery, you can ultimately get your case ready to show the judge. So you can show the judge, here is the paper trail based upon the financial institutions. The next thing you're going to be looking at is valuation. Now, oftentimes valuation is self-evident. So a bank account's bank statement shows what the value is as of the date of the divorce. However, there are certain things such as dissipation that can only be shown by seeing the historical records. Dissipation is spending marital funds on a non-marital purpose. Some classic examples: spending money on a significant other that's not your spouse, partaking in a new gambling addiction or some other thing that the spouse is not a part of. In a situation like that, you need to gather the historical records and you need to itemize every single transaction that you think is dissipation. You then need to show the court and you need to file a notice of dissipation to the other side saying, these are the items we think that you took from the marriage. Ultimately, it's up to them to show what they did with the money. If that money is gone, the court can't all of a sudden put it back in, but what it kind of does is it adds those funds back onto the marital estate. And then it says, okay, had these funds not been dissipated, instead of say $500,000 that we're going to divide, the court can look at it and say, there's $100,000 of dissipation. We're now going to pretend like we're dividing $600,000. And in a situation like that, if the money's all gone, what the court can do is fashion remedies where they make that person whole. Instead of only getting $250,000, they should have gotten $300,000. And the court can say, I'm giving an extra $50,000 to this person. So they would walk away with $300,000. The other side would walk away with $200,000 because this side already dissipated their portion. They've already got their half. So it's really important when you're issuing discovery, you understand what you're doing. What are you trying to prove? Are you doing it just to do it, or is there a purpose behind it? And if you have a purpose behind it, you can work with your legal team to ultimately get what you want. So if you're going through a divorce process and you know you need information or you know your spouse is going to ask for information, you need to have a legal team on your side that understands discovery. In my office, we know what we're doing with this and we'd be happy to help you understand your options to create a plan for you. Give us a call.